Welcome to this week's episode of Case Files, which focuses on public records and some dramatic changes being proposed right now in the Ohio General Assembly.
And Mel, I am going to freely admit that this isn't the most interesting topic we're going to discuss on this show, but it might be the most important. So these changes could completely change how we do our jobs as journalists. So first off, let's watch a story I put together this week on this topic. It'll help explain this a little bit better, and then we'll come back and talk about it. In the last 6 months, charges were dismissed against 5 men previously convicted of a 1992 murder in Toledo's Wilson Park. Now, Toledo police didn't provide the defense or even the prosecutors with evidence that could have cleared Eric Misch, Lorenzo and Mel Vasquez, Louis Castilla, and Joseph Ricard.
We did numerous public records requests, probably about close to 10, if not more, over the course of a decade. And the records that we finally obtained that led to not only Eric's exoneration, but the exoneration of his 4 co-defendants were records that were in the police file for more than 30 years.
On April 9th, the state took the first step in making life much more difficult for Sanchez and wrongful conviction groups. The Ohio House passed a budget bill that made significant changes to public records law, backed by the Ohio Prosecuting Attorneys Association.
We did support the changes to define specific investigatory work product and make it clear that our attorney work product is excluded from the public records law.
In our 2019 Guilty Without Proof investigation, we obtained the prosecutor's case file, which contained notes and strategy. Our investigation led to the release of Wayne Brady and Carl Willis.
Attorney work product privilege is something that every attorney, including prosecutors, should enjoy. And the public policy behind that is that we want attorneys and prosecutors to feel free to reduce their thoughts to writing and to do that without fear of unnecessary interference.
We need to make sure...
Lucas County Prosecutor Julia Bates provided a statement which reads, in part, "We understand the proposed changes to the public records law and the potential impact on transparency. However, it's important to balance that transparency with the need to protect the integrity of ongoing legal proceedings." But on page 463 of the spending bill, specific investigatory work product is defined as information gathered by police for a likely criminal proceeding, which could be interpreted as during any part of their investigation. And on page 473, attorney work product is defined as a record created for an attorney in anticipation of litigation. Now that could include any police record put together for a prosecutor. Law enforcement and attorney work product would be exempted under the bill, possibly hidden from any examination, ever.
I do a lot of international work, and you see stuff like this in like third world countries where they don't have transparency laws, they don't have sunshine laws. Most states here do, and like if this is interpreted in the way that I think they're going to try to interpret it after it passes, it's kind of like putting Ohio up there with like some of these third world countries and not having transparency in public records.
Mark Godsey co-founded the Ohio Innocence Project, which has freed 43 wrongfully convicted people. If the law was how they want it to be, of that 43, how many would you guess that you would have been able to still get out?
I'd have to do the math on it, but close to zero.
Prosecutors want to sideline the 2022 Ohio Supreme Court ruling in Myers versus Myers by strictly defining and shielding investigatory work product.
Called Myers versus Myers, and it said that if an officer on the scene, while taking an initial incident report, also starts to compile what's called their supplement narrative, which contains victim information, witness information, a victim statement, witness statements, the officer on the scene's initial impressions about what the case might involve. This Myers case said that stuff is available by public records request right away.
11 investigates used supplemental reports in the Brady Willis investigation, the Johnny Clark Lisa Straub report, and the investigation in the 2009 murder of Grace Kennedy and Bryan. Supplemental reports actually showed police believed the murder weapon was a lamp information not previously reported. In our Cedar Point investigation, which uncovered dozens of sexual assault claims, was driven by police supplemental reports. Those would not be available to us under the proposed law. Sanchez relied extensively on early police notes in the Mish case.
And the most critical of those records were handwritten police notes from an interview with the victim's uncle that completely upended the state's theory of the case and pointed to Eric and his co-defendant's innocence. And this kind of record is something that potentially could be shielded under these proposed amendments.
Now, a similar attempt was made for changes to the records law 2 years ago. These changes also were added to a budget bill.
We had to man the phones like nonstop for like 48 hours, calling every like senator or representative and saying like, look, this is bad stuff. And, you know, even if you're not even sure, this should be a standalone bill, not stuck into a budget that, you know, people find out about by surprise at the last minute.
Now, Tobin and Bates are concerned about early information being released and potentially derailing a case.
That's very concerning for victims and witnesses, because if their information is available to the public right away, that really increases the risk that they're going to be subjected to witness intimidation, and it really increases the risk that the investigation is not going to get off the ground at all.
So this is why page 454 included an addition that trial preparation records would not be available until after a direct appeal. However, there is no end date for the police records or attorney work product, meaning technically those records may never be released.
The specific investigatory work product provision needs to have a sunset provision that's very similar to Section G for trial preparation material. So after trial preparation material sunset, you need to basically repeat the same thing, but for specific investigatory work product. So that's number one. Number two, the definition of attorney work product later in the statute, in the bill, needs to either be removed or a sunset added to that one. And it also needs to make clear that attorney work product is not talking about the police file.
Tobin believes Godsey and others are overreacting to the intent of the law.
I think they're being a little hyperbolic about what it does. I want to be very clear that anything that's factual, that's in the case file, witness interviews, witness information, lab reports, physical evidence, all of that stuff is still going to be available to the public. It's going to be a little bit longer until they can get it, because we're going to wait until after the direct appeal.
But again, as written, there is no end date for police records or attorney work product, leaving the bill up to interpretation by each department.
If you want police and prosecutors to have the proper training, to have the proper supervision, to have everything work the way it's supposed to look and the way it's supposed to work, you can't have complete secrecy, because through time, corruption will grow and more people will start doing things the wrong way. What keeps powerful people in check is transparency.
The Senate's expected to vote on this bill in June. It could then become law. Now, Godsey wants the process to slow down, addressing the concerns of prosecutors, but also allowing for future examination of cases.
If you allow this to go forward and allow these laws to take place and they are interpreted the way I fear they're going to be interpreted, we've lost all oversight in Ohio, and we can be put in a category with like third world countries in Africa that have no transparency in their criminal justice system.
Now, what we don't know is whether these changes are going to make it through the Senate or whether they're going to get stripped out. But in the weeks ahead, we're going to be asking state senators what they're planning to do. Now, more on this story can be found at WTUL.com. Reporting in the newsroom, this is Brian Duggar for 11 Investigates. So Mel, obviously I am very fired up about this, and it's a very complicated situation, and you know that's why I spent 8.5 minutes trying to explain it and kind of explain to people why it matters.
And why they should care. And I think it has different implications for attorneys and journalists, not always the same.
Absolutely. So we thought it would be a good idea to bring in Michael Stahl. He's a Toledo appellate attorney to kind of talk a little bit more about this. So Mike, I guess the obvious question is, what do you think about this proposal?
Well, so thanks for having me here, Brian. What I'm struggling with is any reason why we need to do this. I didn't hear that from the Prosecutors Association representative. I didn't really hear that from Mrs. Bates. I heard, well, we need to balance things. Well, what are we balancing exactly? The initial time issue, when we're talking about the direct appeal, one thing I think is important to realize on a direct appeal, evidence outside the trial record, which is, the testimony, the exhibits, sometimes pretrial stuff. Other than that, there's nothing you can use in a direct appeal at all. So if I get a police report that wasn't disclosed, that doesn't go before the Court of Appeals. That goes back in the trial court, right? So that's what you had with like the Mish case, with all these different cases, the Stoney Thompson case that I had. All that has to go back to the trial court. There's a couple different mechanisms to do that, but you can't use it in any way in a direct appeal. So I don't understand what the reason for that time frame is. It doesn't matter, right? We're just delaying things. So.
I'm actually curious, did you even know about this proposal? I mean, I know obviously we discussed it, but.
Until you told me about it, I did not. I knew there were some previous changes that had happened, but I didn't know about this. I was kind of surprised by it. And I think, one thing that Mr. Gantz said, this shouldn't be coming through a spending bill. And I think that's right. This is something that there should be a conversation about. There's no shortage of wrongful convictions that go on. And, one thing that's really bothersome about this, the Mish case, I think you mentioned, I have a case in Henry County, the Parsons case, that we're dealing with the same sort of thing where the prosecutors are saying, well, we didn't have this information. I'm pretty sure that that's part of the situation in the Stoney Thompson case as well. Well, how does that happen? And why isn't that an area of, that seems to me far more concerning than any of the issues that I'm hearing raised by the prosecutors about, delaying when we get to see things. Why isn't this getting to the prosecutors in the first place? They're the ones that are actually trained in the law to know what they have to do with this and how they can present evidence. So I've got a lot of trouble with this. I don't think there's a good reason for it. I don't understand the basis for it.
Yeah, I mean, that's my question. They want to delay some of this until after direct appeals, which is, I mean, that could be, a direct appeal could take a year, something like that?
That's the problem I had. I wrote down what this Tobin guy said. He said, the public, it'll just be a little bit longer until the public can get it. But unfortunately, that could be after someone gets put behind bars, and then the chances of getting out on an appeal are less than probably getting convicted of the crime. But if the media can't report on some of these things and attorneys are having a hard time getting it, they have to wait a little bit longer. This person could already be facing a life sentence or even a death sentence at this point.
Well, it certainly could be. And I don't, like I said, I don't understand the distinction because it's not something that's going to take place in the direct appeal process. It's specific in the statute, as I read it, that they're talking about until after the direct appeal's completed. I've heard prosecutors make that argument that, that's how the public record, and I don't understand it. I don't understand why they're making that particular argument because it's not useful in that. It's useful in some kind of post-conviction proceeding, a post-conviction petition or a new trial motion. There's a couple different options you can do, but it's not useful in direct appeal. So why the delay on that?
I wanted to ask you, I know a lot of attorneys, defense attorneys have been prosecutors. Have you ever been a prosecutor?
No.
Okay, because I wanted to see what your take was on the fact that they believe that this attorney work product privilege, they want basically their notes that they're jotting down at any point remain private. That was one of the big concerns that was pointed out. As an attorney, do you see a value in protecting your notes from any sort of public scrutiny at all?
Well, yes, to some extent. So, but attorney work products is a pretty amorphous term. It's not very well defined. It's a privilege attorneys have. So if I'm going through evidence in a case, if I'm going to make notes about a body camera video or something like that, that's not something I'm necessarily going to even include in the client's file, right? I can keep that separate, usually. Now, whether I probably wouldn't, but that's up to the attorney. What they're talking about here is, I think, a little bit different because they're saying investigatory work product, and I think they're confusing two terms. If I'm getting information from the police, that's not my work product. That's the police's work, which is what the statute reads. It's the investigatory work product of the police. The other thing is if I'm acting as a an investigator myself, that's potentially not work product. It can be, right? So, and this is a privilege that operates in civil law too, and it comes up in civil discovery, so there's case law kind of all over the place on that, which is what's concerning about this is they're not defining that very well as far as I could tell in the statute, what exactly we're talking about here. Well, that means it's going to result in litigation. Well, if you're somebody that's trying to get answers, and I don't work for the Innocence Project, and I do this as a private attorney and do a lot of work in post-conviction, and, I have families like, Cullen Parsons' mom is desperately trying to find out what the heck happened in the investigation. It's not necessarily that everybody's convinced that, their son's innocent or whatever. It's just what happened here. There's questions that aren't answered. First of all, why do you have to wait for it? But then why do you have to litigate? So certainly if this passes, we're going to get an argument on just about everything being attorney product, which means I have to then argue that if it's in the Henry County case, we go to the 3rd District after, we go to the trial court first, we go to the 3rd District, go to the Ohio Supreme Court. That might take a year. That might take 2 years if we even get heard on it. And all the time is being spent, litigation's going forward, and all this costs an enormous amount of money, and it costs an emotional toll because you're just getting an answer.
Yeah. And you had mentioned that, this is kind of tucked into the Ohio budget bill, which everyone, this happened 2 years ago, but Mark Godsey, who's the director of the Ohio Innocence Project, that group is largely leading the charge against trying to fight these changes. And he kind of talked about how we got to the point where we are. So let's listen to that.
Sure.
And 2 years ago, right before the budget came up for the final vote, we realized that the prosecutors union had slipped in language into the budget bill that really undercut the ability to get public records in criminal cases. So we had to man the phones like nonstop for like 48 hours, calling every like senator and representative and saying like, look, this is bad stuff. And, even if you're not even sure, this should be a standalone bill, not stuck into a budget that, people find out about by surprise at the last minute. And we were able to get it pulled. And so the sort of understanding was that they were going to resubmit this as a standalone bill, which they never did, I think, because when it's actually scrutinized, they can't get traction for it. So it gets no traction over 2 years. They can't get the support to introduce it. So the same card is played as 2 years ago. It's like slid into the budget.
So Mel, when you think about this, right now it's in the budget bill, and this budget bill is 4,000 pages long. So at some point we're going to get.
I think you pointed out 2 pages where this applies.
Right. And so at some point we're going to get to where the House and the Senate agree on this, and they're going to vote. And then the representatives and the senators are going to say, well, do I want the budget to pass or don't I? And if they do, these public record changes are also going to pass with it. So what Godsey is saying in that quote, or in that soundbite, is that why can't we take it out of the budget bill? Let's make it a standalone bill.
Because nobody will support it, except the prosecutors.
That seems to be his thought.
Because then you go into, this is a First Amendment problem, very clearly to me. I think it's a First Amendment issue.
Yeah, because the representatives and the senators, they don't want to take on the public records law because these are dramatic changes. We're not talking about 1 or 2 little things. We're talking about dozens of changes.
And I will also say, we have a hard enough time getting public records, to be honest. It is a battle we fight every day. Some of these entities that we work with use it as a tool to express when they're not happy with us. And, what are you going to do? You're going to take them to court. That's what we can do. We can go through the Ohio Attorney General's office and take them to court. But I will point out that I looked up it's called, so we're not talking about federal here. We're talking about state. Right. And so different states have different public records laws. And I looked up Ohio's, it's a sunshine law is what it's called. Some of the things that I think really hamper us already is the reasonable time. So some states will point out what is a reasonable time. And what I mean by that is when we submit a public records request, it has to be produced in a reasonable time. But in Ohio law, that's not defined. Other cases, it is defined. It could be 5 days, it could be 7 days, 10 days to produce these records. And if they're not produced, then we have a clear timeline to state that there's an issue here. Already, Ohio law doesn't help us out because what is reasonable time? We can't determine that. That would have to go to a court to determine that. So it's already hard enough.
Yeah, I mean, it's a constant battle for us because, I mean, and I think that's also the Ohio Innocence concern about this. It's going to be how people interpret it. And when we deal with people trying to get records from this, and Mike, you know this too, when you're trying to get records, they're going to interpret this as broadly as they can to try to restrict what they have to give you.
Certainly. And, you know, I think there's two aspects of this, and they're both constitutional. One's the First Amendment, and I think you're right. That's a little bit different issue than what I deal with. I think, you know, especially if you're reporting a case that's ongoing, my view is that the more openness, the better. I would rather have wrongful convictions not happen. We have something that's supposed to prevent that. It's called a trial. But when we don't have the process being followed, I'm of the view that really we shouldn't have to be relying on public records to find due process problems. And I think part of the issue here, this was mentioned a couple of years ago, the Ohio Supreme Court had a task force on wrongful convictions. And as part of what they mentioned is there really isn't much oversight of local county prosecutors. It isn't like the Ohio Attorney General is their boss or a supervisor, or really, unless they ask him to come in, my understanding is they're not, right? So who's looking at this other than the political official? So I think there's a kind of a systemic problem there that I don't know that public records cures it. It's a fix partially because we can get access to it, but it's maybe not the best fix. And so I think it is two different issues, and it seems to me that there ought to be a clarification on a lot of this material in here.
Yeah, and I don't want to get too deep in the weeds here, but as an appellate attorney, I'm guessing you deal with discovery a lot of times. Like these innocence groups, they're dealing with, you know, I've talked to some of them, and some of these cases for them are like 20, 30 years old, and maybe the original trial attorney isn't even alive. Maybe he doesn't have good record keeping and he loses the record. Maybe there was a flood and the records were damaged. So, you know, one of the things the prosecutors say is like, well, Ohio, we have open discovery and, you know, they can get these records. But when you're dealing with these innocence groups, it's very difficult for them to get records from a trial attorney.
Well, it can be hard for a trial attorney. Sometimes it's even hard for prosecutors to get the records on old cases. You know, we've been dealing with some of that with the Willie Knighton case, where the prosecutor's office didn't have the transcripts. Fortunately, he had the transcripts from the Ohio Innocence Project. They got them way back when, so the transcripts are out there, but where did they go exactly? I've never quite understood that. You know, they should have been available, and it can be a real problem, you know, because this happened in the Stoney Thompson case. The trial court record was, even what was put up towards the Court of Appeals, they'd actually used the record in Goldie Thompson's case. It's the same exhibits and everything. I guess I can see why, but then we had to look at them and compare them and supplement the record with it. And, you know, that's an issue too, that it's hard to get things. And you're right, sometimes it's hard to come up with the original discovery. You need to know that to see what the original trial attorney saw.
I think that would really help clarify things for people too, because there is a difference between, people may look at this and say, well, why can't an attorney get discovery at this point in a litigation? So why does an attorney sometimes have to access public records?
So that's a good point, because people do not understand this. Even investigators, sometimes they work with, don't understand this. So prior to trial, you know, the Constitution, federal and the state, gives you subpoena power. I can get pretty much whatever I want, or at least try to, unless the judge says no, and then it's an appellate issue, right? You can subpoena it. You don't even have to rely on discovery. After a trial's concluded, unless there's a hearing ordered, like the Parsons case where we had the prosecutor testify, right? Because he said things that were completely contrary to the record that we got. And he's like, oh, well, no, I never had that, right? Well, unless you have that hearing called where you can issue subpoenas, you don't have the ability to issue a subpoena. there's nothing.
You have to have an open case.
You got to have a case, but you have to have some way to get to a subpoena. So the only thing you can do is go do investigation without that, and part of which can be public records. Now, usually it's not actually the defendant even seeking that. Like the cases I have, it's usually the person's family that's coming forward and saying, there's something wrong with this. They've been complaining about this. You know, this isn't somebody that's incarcerated looking for records. It's somebody else. Now, you can wind up representing them both, but to get to the records themselves. And should there be a change in that? It would be nice to be able to have some better access to that. And maybe the way to do that is through some sort of an oversight body. Because I can also understand it, public policy issue of just not having maybe able to go to subpoena everybody willy-nilly. I'd be almost a roving grand jury
Right.
at that point. But when there are specific things, we ought to be able to look at them a little more closely than we can. I mean, there are some options, but you'd have to be in pretty serious corruption territory to
It
go to
just
the
blows
Attorney
my mind that
General.
an attorney would have to access a public record like any of us.
Yeah. And, you know, talking to the prosecutors, particularly Lou Tobin and the Prosecutors Association, you know, he said one of their goals with these amendments is to essentially overturn 2 Ohio Supreme Court cases. One of them was Myers versus Myers. The other one was Castor versus Columbus. And what Myers versus Myers did, it essentially made supplemental police reports available to the public. We use them a lot in our Cedar Point investigation, you know, which we found all the sexual assault cases. We relied extensively on these supplemental reports. And so you think about a police incident report, that gives you basic information like
Who, what,
the time
when,
of the
and
call.
where.
Yeah, exactly. But a supplemental report requires, you know, it includes like officers' observations, maybe some witness statements, and a bunch of other stuff that's really, like some of the cold cases we do, we rely on them to kind of be able to build that narrative. So the prosecutors are saying, well, we don't want this information out there because it can jeopardize the case. It can cause witness intimidation. Too much information out there can just sabotage the investigation before it gets off the ground. So what would your response be to that?
You know, as far as the witness intimidation thing, I think that might be, to use Mr. Tubin's word, a little hyperbolic. I think that's pretty uncommon and pretty rare. I think prosecutors think that that's a possibility. I think it's less likely to occur than they think it does. There is, you know, I can see when an investigation's ongoing, you know, you hear something from one person, you want to go talk to somebody else first before anybody else does. I can see there's an interest in some confidentiality in that. You know, if I send an investigator out to talk to somebody, we get some information, I'm not necessarily just going to go run with that. I'm going to want to get verified and figure out what's happening. So I can see some basis on that. I'm a little less clear as to what the basis would be once a charge is brought. You know, once we're, at least theoretically, the investigation is over, seems like that's where your role is more paramount. And I'm a historian as well, and I think one thing that's happened over the course of 50, 60 years, there used to be a whole lot more local crime reporting.
Agree. I was just getting ready to bring this up. We do not, when is the last time that we ever went into a police report and said, this was the witness to this? We don't do that. And the only thing I can think of is that this is somehow an attack on independent journalists who now are doing all these YouTube channels, and what we've really seen a lot is these Facebook people going out and reporting and stuff like that. I'm just thinking, I have never seen in this, as long as I've been reporting 21 years, I don't see any reporters going out and saying, Joe Smith said that this guy had the gun. If anything, we maybe would go see Joe Smith, but unless he wanted to talk to us, we'd leave him alone. We wouldn't throw his name out there. I agree with him.
Yeah, and in fact, we often have meetings and discuss these very things. We're like, well, we don't want to endanger somebody, obviously. I mean, we're trying to help. We're not trying to hurt a case. So, yeah, I mean, you know, maybe some journalists don't do that. Maybe they don't care. But, you know, here we do try to be respectful and kind of consider everything that could possibly result from our actions. But, you know, Mel, I actually got ahead of myself a little bit here, and I wanted to play what Lou Tobin told me about these two cases we're talking about.
We did support the changes to define specific investigatory work product and make it clear that our attorney work product is excluded from the public records law. You know, it's always been the case in 149.43 that those two things were excluded from the definition of what a public record is. And over the last several years, the Supreme Court has kind of created its own exceptions to that.
Yeah, that didn't well, he goes on to discuss Myers versus Myers and Castor. In Castor, which we haven't talked about, that essentially made the case files available after the original criminal trial, correct?
Correct. And the rationale for that, you know, it said a pending, I believe it was pending litigation or pending case or something like that. Previous to that, there was a decision called Streckman from, I think it was the 80s, somewhere in there, that rationalized that no, that really doesn't apply until effectively any chance of doing anything with the case is over. So in other words, whoever you're talking about is dead, basically. Well, in the intervening time, Ohio changed Criminal Rule 16, which is the discovery rule. Part of the rationale on that Streckman case was, well, these people are going to wind up getting more stuff from public records than they got from discovery in the first place, and that's not going to be fair because it'll go back to trial and then they're going to have more evidence. Well, Criminal Rule 16, as it's written now, virtually everything's going to be supposed to be presented in discovery anyway. And the other issue I have with that is, and that was discussed pretty thoroughly in the Castor case, the other issue I have with that is, so what am I going to get? The only thing that I'm going to get, or a defendant or anybody that's going to get through public records, no matter who's getting them, right? The defendants themselves, by the way, are excluded from being able to get those unless the court lets them do that, which is, you know, but families can, it's not, you know. But in Castor, they discussed that and said, look, you know, the discovery rules changed. Well, the other part of that is, well, if it's not something that should have been disclosed as exculpatory evidence or maybe shows that one of your witnesses was not being truthful, it's not going to do any good. It's not going to matter. Mm-hmm. So, you know, potentially they could withhold additional inculpatory evidence, additional evidence that you committed the crime. You know, maybe they have some other eyewitness that they don't want to disclose or something that says you did this. Well, that's not going to do me any good, right? Yeah. So so what are we hiding? We're hiding things that should have been turned over not under Criminal Rule 16, but under due process, under Brady, which predates criminal discovery in Ohio.
But let me ask you this. So again, in talking with Lewis, he said the intent of that, making it after the direct appeals, is that right now defendants have an advantage when they go into the appeals because they know what the attorney's strategy was. They know what their thought process was. They have access to all these supplemental reports. And this was his argument that he's trying to level the playing field. So once it gets to this appeals level, which you're obviously very familiar with, that the defense has an advantage.
Well, we don't.
I don't think that,
that's not accurate.
Sense.
And the other thing is Criminal Rule 16 plainly says all police reports. That includes supplemental, it includes, the rationale he's talking about is the rationale from Streckman, which I challenge to some extent because I have a problem with that theory, but it's undermined by the new Criminal Rule 16, which the prosecutors were part of developing that. And the purpose was to ensure we had fair trials. I think in some part they were trying to address partly issues that we've seen here where evidence hasn't been turned over to the prosecutor. Well, if you have a discovery rule where there's an attorney looking at this, if they're doing their job, right, they're going to see, well, wait a minute, where's this, what's this, what's that, right? And they're going to ask for more stuff. Or they're going to go subpoena it, or they're going to do whatever they need to do. And so it has more eyes on the ball. And I think that's an important thing that's lost in this. And as far as direct appeal, it's the trial court record, which I think there might be some confusion on that. Sometimes even trial lawyers get a little bit confused about that. I've seen cases where, you know, they attach exhibits to
You would hope if he's trying to clamp down on the First Amendment that he's clear on, you know, the rules right now. This just smells fishy to me. I don't buy that it's to prevent witness intimidation or protect some notes. What do you think is really at the crux of the issue here? Why is this being done?
I think that there's been a number of cases, including here locally, and you know, you guys deserve great credit on that, the work that you've done on these, that I think they're afraid to have things come forward. I think that they don't know how bad it is, and I think that's a fair thing to know, to think.
When you say you don't think they know how bad what is?
How bad so there's a fairly limited amount of like exonerations that have occurred, correct? There's a lot though, you know, if you compare it to the whole sea of criminal defendants. That said, we're somewhere over 4,000 of them at this point. And there's no real metric. There's no way to say how many more there are. Nor is there any way to say how often it happens where either the police or the prosecutor or somebody crosses a line and hides things. And you can see how this happens. If you're in law enforcement or something, you become convinced that you know somebody did this. And then you get a piece of evidence that points the other way. And maybe you don't think it's credible, you know, right? And so you don't turn it over, or it doesn't go to the prosecutor, or the prosecutor doesn't turn it over. However it happens, the problem with that is we're undermining the core of our system. Who decides credibility? The jury, or a judge, I guess, if you try a case to the bench. Well, it's not police and prosecutors. So it's a real issue.
Which
I think
the prosecutor should be operating independent of the police. They should be going in there with their eyes wide open to every scenario and looking for justice, whether they agree with it or they don't.
100%. You know, that's why we see conviction
So then
integrity
this makes me feel even more uncomfortable.
I'm not sure what they're afraid of. And I think part of it is just, we're going to have to do something about this, and it's easier to not. You know, if the
Easier to go
issues,
after the First Amendment.
If the issues don't come up, we don't have to deal with it. And there's probably a lot of belief that, you know, we got the right guy in the first place, right? That's part of...
And most of the time they do.
And most of the time they do. And most of the time they do. And even sometimes when there's conflicting evidence. I mentioned about the notes that they're talking about. One thing about that provision on the notes in that statute, it really bothers me. The Glossop versus Oklahoma case came out in February, which is a death penalty case that they reversed for false testimony. That was based upon prosecutors' notes, and it was actually a fairly thin amount of notes. I mean, it just said Dr. Trumpet, which was actually a guy named Dr. Trumpka, if you look at the decision, right? But and then that he had been prescribed lithium, and then some other kind of vague things in there. Supreme Court of the United States reversed that case, ordered a, I think it's the third new trial, maybe it's even the fourth. It was a bunch, but that's way back in the 90s. Who is going to be able to put that sort of thing together, right? So I think that's part of what they're reacting to. They're concerned about that something may go wrong with that. I can see that. It just means more that.
But just say it. You know what I mean? Just say, listen, I take my notes, and at some points during the case, I'm not sure what's what, and I'm writing notes, and, you know, just say.
Right. And see that.
Don't try to hide it and say, you know.
And there's where the work product question comes in, because I would not consider the notes in the Glossop case to be a turning work product, because they're interviewing Glossop. And it's two lawyers that are doing it, but they're taking notes on the interview. Well, that's a witness statement, at least to some extent. You know, I don't know that that's really should fall within the ambit of attorney work product, especially in the criminal context. You know, we're talking about capital case, so.
You know, my buddy actually asked me this question last night. He said, you know, what you should have asked the prosecutors was, can you give me an example of a case that you lost or that fell apart because, you know, the supplemental report was out there, or because of attorney work product notes or whatever. Can you think of something that fell apart because?
The closest one would be Glossop, but the reason Glossop fell apart would be because the Supreme Court decided that it was false testimony. I mean, and it's not exactly a wild-eyed liberal Supreme Court we're dealing with. You know, I actually agree with Justice Thomas in there that they went a little bit further than the prior case law on that. Because the way they found the overturning, and maybe that's part of their concern too, because it's possible that you could argue, and I might, that if you discover this sort of thing, it's now a broader rule So if that's in the discovery file and it wasn't brought attention before, I may have an opportunity to bring that out again under the delayed post-conviction rule. So I can see that being part of the problem. They just don't want to have that out there. And it could be that it's just, it's a concern over sloppiness, because I'll concede the gloss of notes were pretty thin. I didn't know which way that case was going to go.
Yeah. And Mel, I want to talk about, again, how we use particularly the supplemental police reports. And I had done several stories on Eric Misch. Eric Misch and these 4 other guys were convicted of a 1992 murder in Toledo. And what ended up happening is that they discovered, lo and behold, the police didn't turn over crucial information to not only his defense attorneys, but also to the prosecutors. They never got this either. So when the Wrongful Conviction Project got involved in this, and they shared some of the information with me, and I looked into it, a lot of the stuff that they were able to get was through these early police reports. And, and their belief is now that this would not be available under the current law. And actually, Joanna Sanchez, who was Eric Misch's attorney, she talked about the process, and let's watch what she had to say.
When we were working on Eric Misch's case, we did numerous public records requests, probably about close to 10, if not more, over the course of a decade. And the records that we finally obtained that led to not only Eric's exoneration, but the exoneration of his 4 co-defendants were records that were in the police file for more than 30 years. And the most critical of those records were handwritten police notes from an interview with the victim's uncle that completely upended the state's theory of the case and pointed to Eric and his co-defendants' innocence. And this kind of record is something that potentially could be shielded under these proposed amendments. And, had we not discovered that in Eric's case, these 5 men may never have been cleared, which would have been disastrous. They spent more than 130 years collectively in prison for a crime they did not commit.
Yeah. So again, Mike, Tobin accuses Godsey of being, hyperbolic and saying we're just overreacting. They're overreacting to all of this. But you heard about the Eric Misch case. Should we be concerned? I mean, should innocence groups be concerned that they're not going to be able to get access to this?
Absolutely. I think it's really troubling, especially the part where we're talking about records that didn't even get to the prosecutor. And I've seen this repeatedly, and there was a police detective in Fremont in the Heather Bogle case, went to prison for 2 years.
Yes, we just reported on, we just revisited that case.
And
Lots of botching.
I don't know the exact details
there.
of that. I'm from Fremont, so I looked into the BCI file on that a little bit, and I'm a little bit concerned about the case, frankly, even the new conviction that they got. But, here's somebody that, it's a DNA, the inconclusive DNA, I think it was, that wasn't turned over to Tim Braun, who's no longer an attorney anymore.
Yeah,
but,
that's another.
Right, so,
That's a
and he
whole
gets
other story.
prosecuted, right, but he gets prosecuted, the detective gets prosecuted for tampering with evidence and sent to prison for 2 years on that. And, well, how is this any different? We're talking about serious cases. If it doesn't clear that hurdle to getting to the prosecutor, I think that's something. I would rather see the Prosecutors Association being more worried about that. I'm worried about that because it's not right.
This leads perfectly into, we're talking a lot of legal stuff here. We're talking a lot of First Amendment stuff and journalism stuff. If people are watching this right now, why should the everyday person care about this? If they say, oh, I'm never going to be in the criminal justice system, blah, 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 this could never affect me. Is that true?
First of all, I don't think that is true. I think, unfortunately, we've got a system that I don't think a lot of people have much reliance on. Certainly people that have experienced the system don't have a lot of reliance on it being able to consistently produce accurate results. I like our system. I think it's a good one. I think it has, over the last century, we've lost a lot of the due process concerns. We have plea bargains rather than trials. A huge amount of problems, but one of them is this, making sure that we've got integrity going through the investigations and getting to law enforcement, getting public scrutiny. and that's an important thing. And there's a room in the Lucas County Courthouse that I believe is filled with boxes that says press on it. You just don't see if there's something big going on there, but they used to hang out there. This was back in the 30s, 40s, and 50s.
Yeah, Julia Bates, she had
I don't think we're allowed in there anymore.
It has your name on it.
Julia Bates actually came into the station, last week, and she was talking about that there is still that press room over there, and she actually encouraged us to, hey, we should come in and talk to the bailiffs, and not many people use that press room anymore, but it is still there.
Well, there's just not as much local reporting as there once was, and I don't think that's really good for our system. It needs that public scrutiny.
Yeah, and I actually think that's why this is kind of slipping through the system. Because, Godsey mentioned that, 10, 15 years ago, newspapers and TV stations, they had these big lobbyist groups that would be able to come forward and tell the representatives and the senators, hey, this is bad, you got to do something. And they would listen to them. At this point, there's really no one, banging the drum
People don't like
this.
the press. People don't like the press. So no one's really coming to our aid or our defense. But do you see this being brought to the forefront? To our knowledge, I found one article in the Indy Star about how Ohio's public records law is being jeopardized. And where was the other one? Cincinnati or something like that.
USA Today.
USA Today. But do you see anybody that's going to start paying attention to this?
I would hope so.
And who would that be?
Well, I think the public will. Hopefully people watch your reporting on this. First of all, you have to know about it before you can pay attention to it. I think the inner workings of the criminal system are largely a mystery to people. Nobody goes and watches trials anymore. Nobody goes and sees this stuff, so we don't know as well as we once did just as a society. So I think that's part of the problem, but I think people do, and there's a reason this was attached to a spending bill rather than the Prosecutors Attorney Association out there with the trumpet, hey, we're going to go do this. They didn't do that. They attached to a spending bill, and then they used language which is less than specific, I think is the best way to put that.
One of the biggest problems with it.
And why not? Why not be very specific about what you're talking about? Why leave this to litigation? You're asking the local sheriffs around to make, whoever is getting the records request to make these determinations, but you're not putting that in the statute, so you're leaving it open. So why do that? Well, there's a reason for that. They're not going to get the support for it. Godsey's right on that.
Yeah, and at this point, we want to look at, where are we now? So on April 9th, this passed the Ohio House. It's in the Ohio Senate now. They're due debates on the spending bill. Senators will have an option to provide amendments to it, and then the Senate will vote on it. And then go ask the House, do you agree with this? You okay with everything we did? If they don't, then they kind of bounce it back and forth until they get to the point where, both sides agree. And then it'll go to Governor Mike DeWine, who I believe by like June 25th.
And that's where all the political inner workings happen, right? Because someone can say, hey, I want this Ohio records thing out of here. And then a lobbyist will come in and say, no, we want it in, right?
Yeah.
I mean, that's where it gets really political.
Yeah, absolutely. And Governor Mike DeWine, he actually has line item veto power. So whenever it gets to him, so if the public records are in there, he actually does have line item veto power.
But he's the former Attorney General of the state. I don't see him going against prosecutors, do you?
You wouldn't think so, but remember the Prosecutors Association is just a lobby group, effectively. I mean, it's not like that's anything. They're not elected. They're just something people join with. Governor DeWine's actually, he increased indigent offense rates. He's actually not been terrible, and it's more or less terminated execution. So I don't know that I would say that it's entirely impossible.
Yeah. So again, I think we just need to alert people to the fact of what's going on. And Godsey told me, he's like, look, I don't necessarily disagree with the prosecutors, but we actually have a soundbite there. I want to play two sound bites. I want to play one where Godsey talked about how he believed this is putting us down a really bad path. And then right after that, he's going to talk about what he thinks needs to be done. So let's listen to those two sound bites.
I do a lot of international work, and you see stuff like this in like third world countries where they don't have transparency laws, they don't have sunshine laws. Most states here do, and like if this is interpreted in the way that I think they're going to try to interpret it after it passes, it's kind of like putting Ohio up there with like some of these third world countries and not having transparency in public records.
So you said you freed 43 people. I don't know if you'd be able to put a percentage on it, but of that total, I mean, if the law was how they want it to be, of that 43, how many would you guess that you would have been able to still get out?
I'd have to do the math on it, but close to zero. I mean, if I, that would be a big research project, but if I go through and try to find someone that we got out and we didn't need the public records, I can't think of one off the top of my head. So it's really low. It's from right now, it's zero, unless I could go through all the files and see if there was one that actually got out without public records. The specific investigatory work product provision needs to have a sunset provision that's very similar to Section G for trial preparation material. So after trial preparation material sunset, you need to basically repeat the same thing, but for specific investigatory work product. So that's number one. Number two, the definition of attorney work product later in the statute, in the bill, needs to either be removed or a sunset added to that one. And it also needs to make clear that attorney work product is not talking about the police file. All of a sudden now prosecutors could then say, well, the entire investigation was preparing for an attorney because it all eventually goes to the prosecutor, and that's the final purpose of it. So now we're cloaking the entire police file under attorney work product.
Right, and again, Mike, he said that I don't necessarily disagree with the prosecutors, but we need a time frame. We can't just shield these things forever. Whether it's after direct appeal, whether it's at the trial, there needs to be a time frame. Any thoughts on that?
I'd agree that I think there needs to be a time frame. I don't know that I think I do disagree with the prosecutor, or at least with the law, especially as far as the time frame being, well, we're going to wait until the direct appeal is over. I don't think that makes a lot of sense because I don't think it affects things materially. I don't, it takes a while to get public records anyway, so, and it's not going to prevent any further action. So I think I do disagree with that. I don't think that makes sense. I think it makes sense to have it after the trial. I think, if they're following discovery rules, the material should be out there. And if there's material they didn't have that comes out of the police department from records requests, they ought to be concerned about that. Mm-hmm. That's just that fixing it this way is not the way to fix it.
Do you guys have any predictions for how this is going to shake out?
Well, right now, I mean, it's not looking good. I mean, the House and the Senate, I mean, they are kind of marching in the same direction on a lot of things. So it's hard to see this changing unless there's a big enough outcry, enough publicity about it.
Mike?
Yeah, I think it needs attention to get it to stop. It's going to be complicated to do at this point because the it's a spending bill. They've got to pass something at some point, or they stop paying for things. So it makes it tricky, and it's not the right way to go about this, I don't think.
All right, more to come. We'll be sure to update you as that makes its way through the Senate and we get that final outcome. Thanks for joining us here on 11 Investigates Case Files. Mike, appreciate your time and your expertise and insight. We'll see you here next week.